much prison time could Donald Trump face? During their investigation of Harold Martin's property in Maryland in the fall of 2016, FBI agents discovered classified materials dispersed around his home, car, and storage shed, some of which were deemed to be of the highest level of confidentiality. The former National Security Agency contractor did not challenge the claims and ultimately pleaded guilty in 2019, saying that his actions were wrong, illegal, and highly questionable. This is in contrast to the previous president of the United States, Donald Trump, who did contest the allegations. Even though he expressed regret and pleaded guilty to a single count of willfully retaining national defense material, the judge still sentenced him to 9 years in jail as a heavy punishment. The outcome of this case may serve as an unsettling guidepost for the potential legal peril that President Trump will face as he defends himself against 37 felony counts. 31 of these counts are brought under the same century-old Espionage Act provision that was used to prosecute Paul Martin and other defendants, who are believed to have unlawfully maintained confidential documents. Even many people who, like Martin, have pled guilty and accepted responsibility for their actions have, despite this, been hit with lengthy prison sentences. When they decide to pursue a willful mishandling case, it is to send a message that we take these cases very seriously, said Michael Zweiback, a defense lawyer and former prosecutor for the Justice Department. When they decide to pursue a willful mishandling case, it is to send a message that we take these cases very seriously. They are nearly always interested in serving time in jail. The public has been made aware of the most recent list of federal charges that will be brought against former President Donald Trump. However, there is still a long way to go. This path will result in a sentence for the defendant if they are found guilty in the end. The defendant is facing charges under the Espionage Act, which carries a maximum term of 10 years in jail if convicted. Both the accusation of tampering, in addition to the related allegation of conspiracy, and the charge of concealment, carry a potential maximum punishment of 20 years in prison. Each of the allegations of conspiring to conceal information and making false statements carries a potential maximum punishment of 5 years in jail. An emphasis on the statutory maximums, rather than taking into account the myriad of other elements that go into determining a sentence in a criminal case, can be deceptive. The courts are required by federal law, specifically 18 U.S.C. 3553, to determine a punishment based on a series of factors before passing judgment. The United States Sentencing Commission, USSC, is responsible for publishing the sentencing guidelines to provide assistance to the courts and encourage the consistent application of criminal law. If there are enough comparable cases, the trends in the sentences handed down in those cases can serve as a point of comparison. This brief explanation provides a general concept of how a sentence might be computed, but it should be kept in mind that issues such as punishment on multiple counts of conviction, connected conduct, and new factual developments could come up. By the provisions of Section 3553, the courts are required to investigate the nature and circumstances of the offense, as well as the qualities of the defendant. In addition to this, it mandates that the courts take into consideration the goals of imposing criminal punishments, specifically the requirements to apply a punishment that is proportional to the gravity of the crime that was committed, encourage compliance with the law, and administer appropriate punishments, deter future criminal behavior, protect the general public from any potential future illegal behavior on the part of the defendant, rehabilitate the patient by providing them with training, medical attention, and any other treatment they require. Avoid creating unnecessary discrepancies between defendants who are in similar positions and have participated in similar behavior. The sentencing guidelines must also be used by the statute's requirements. However, the Supreme Court has ruled that a sentencing judge must give serious consideration to the extent of any departure from the guidelines and must explain her reasoning if she imposes an exceptionally lenient or punitive sentence. Although the guidelines are advisory and not mandatory, the Supreme Court has ruled that a judge must give serious consideration to the extent of any departure from the guidelines. The guidelines itself lay out several broad principles, after which they specify the number of specific base offense levels for certain offenses. They give changes that are based on considerations relating to victims, a defendant's role in the incident, any obstruction or related activity, the treatment of multiple counts, and a defendant's acceptance of responsibility for their actions. Each of these considerations results in either an increase or decrease of a predetermined number of points. After obtaining the overall value, one can next make a comparison to a chart that gives sentence ranges based on a defendant's prior criminal record. Application to the charges brought by the special counsel. If the information at issue was classified top secret, as is stated in the indictment against Trump, 2M3.3, the base level for deliberately retaining national defense information in violation of 18 U.S.C. 793 is increased to 29. The base level for knowingly retaining national defense information in violation of 18 U.S.C. 793 is 24. If a defendant was the organizer or leader of criminal activity that involved at least 5 people or was otherwise extensive, for example, conduct that relied on the assistance of unwitting outsiders, the defendant's leadership role in the crime could add 4 points to the total score. However, if the defendant organized or led criminal activity that involved fewer people and was not as extensive, the defendant's leadership role in the crime could only add 2 points to the total score. 3B1.1. The indictment makes the allegation that the defendant was the organizer or leader of criminal activity that involved at least 5 other people, regardless of whether or not they were all witting, Walti Nada, Employee 2, and Attorneys 1 to 3, and as a result, the attorneys for the defendant will consider making calculations based on the 4-point increase. On the other hand, a defendant may be eligible for point deductions, Section 3B1.2, if their role was insignificant. According to Section 3B1.3 of the Guidelines, a defendant receives an additional point for abusing a public or private trust to conduct the offense, because the defendant frequently came into access to national security information while in a position of public trust, and indeed by that position. The courts routinely add those extra points in cases involving Section 793 because of the nature of the material. If the defendant willfully obstructed the investigation, prosecution, or sentence of the offense at issue, then the offender will receive an additional 2 points, according to Section 3C1.1. The obstruction points are not applied to infractions of statutes that themselves prohibit obstruction, except in a few specific cases. When a defendant admits guilt or otherwise takes responsibility for their actions, the severity of the offense they are charged with is reduced by 2 points. It is up to the discretion of the prosecutor to decide whether or not an extra point reduction of 1 should be applied. In that case, the court would need to approve the rationale for the reduction in response to a motion by the government. It is essential to emphasize once more that the guidelines are merely advisory, and that Section 3553 instructs the courts to impose sentences that are commensurate with prior instances that involve defendants who committed offenses of a comparable nature under circumstances that are analogous to those in the current case. Due to the low number of cases and the variety of elements that are involved in each case, it can be difficult to determine which cases fall under the purview of Section 793 retention. Both sides will present examples of prior sentences involving retention and disclosure, and they will attempt to reason by analogy if the former president is found guilty of 1 or more counts of Section 793. However, the United States v. Donald J. Trump case is an unprecedented one for a variety of reasons, some of which may be relevant to the sentencing process. Do you like it? Kindly give your valuable response in our comment section below. And don't forget to subscribe to our YouTube channel for more interesting and informative videos.